the punchline of this episode could be you don't have to make any change. All the change, and if you failed to make the changes that were required of you July 1st, then you're good. I think for the three of us, what we really want to communicate here is how should employers be behaving? Because one thing is certain, nothing is going to stay the same. Welcome to Mission to Grow, the small business guide to cash, compliance, and the war for talent. I'm your host, Mike Vannoy. Each week, we'll bring you experts in accounting, finance, human resources, benefits, employment law, and more. You'll learn ways to access capital through creative financing and tax strategies, tactical information you need to stay compliant with ever-changing employment laws, and people strategies you need to win the war for talent. Mission to Grow is sponsored by Assure. Assure helps more than 100,000 businesses get access to capital, stay compliant, and develop the talent they need to grow. Enjoy the show. Hi, welcome to today's show. We got a big topic today. So an East Texas court on November 15th overturned a really big Department of Labor decision. We've talked a lot about it on the show. I got two guests. If you're regular watchers, you know Mary Simmons, you know Brian Shenker, experts in this area. We've talked a lot about this topic, trying to prepare employers for these really big, super impactful rule changes. And now it's all changing yet again, going back, but some of these rules have already been implemented. Let me just kind of unpack the topic, and then we're going to have a discussion, hoping that today's episode we get really practical for business owners. What the heck do you do about this information? Because if you haven't acted yet, maybe there's nothing you have to do. If you are proactive in making adjustments, there might be changes you have to make to actually be legal here. So let's just unpack it. So prior to July 1st, 2024, so the minimum salary threshold for exempt employees, that means you might think of it salary, the eyes of the law, it's exempt employees. They don't get overtime. Under the Fair Labor Standards Act, FLSA was $684 a week, the equivalent of $35,568 annually. So, and that hadn't changed in a very long time. So Department of Labor published rules, so went through this whole big long process where after July 1st of 2024, so a few months ago, that was going to $844 per week or $43,888 annually. So a big jump from $35,000 and change to $43,000 and change, with a further increase scheduled for January 1st that took it up to $58,656. So big change from before July 1st, after July 1st, and an even bigger change here. Here's the big news. On November 15th, the U.S. District Court of Eastern District of Texas vacated the DOL's rule, effectively reverting the minimum salary threshold back to pre-July 1, 2024 levels of $35,568 annually. Okay, so let's go to the group here. What the heck does this mean for employers? This is big, sweeping change. I just fear so many employers don't even know about this. I think we should start with the baseline of what is the rule? What did the Texas court do? And then how must we react to it? And Mary, I'll maybe start with you.
Yeah, thanks, Mike. I mean, first of all, and Brian will weigh in on this also, it is very rare that it gets enacted and then they pull it back. So you have employers, hey, listen, if they didn't know that this was out there, they're almost in better shape than the clients that we have that listen to us had made those raises in July. I think it's uber important for employers to, number one, understand FLSA and the difference between exempt and non-exempt. It is very often that I'm on the phone with an employer. Everybody understands minimum wage for your non-exempt people. Everybody understands it. They might not be up to date on all the changes because there's a lot of changes there as well, because it's federal, state, and municipalities, right? Jumping into that race. There's about 150 different ones. But a lot of the employers don't understand that there's also a minimum salary. And what we were talking about here, of course, is your white collar exemptions. And there is other exemptions. We've talked about that on other episodes. But I think a lot of employers don't even understand the baseline, and that's understandable. They're running their business. This is what Brian and I do every day. So it's our world. And that's why I think it's valuable for us to go through this and explain that these laws exist. So if you never made the changes, you should be in good shape, but it doesn't minimize the fact that you have to go back and have a job description for every single position that is very clear and defends the exemption, be it exempt or non-exempt.
Very well said, Mary.
Yeah, there's a million ways we could go there. Brian, I'm going to let you react to Mary's comment here first.
Yeah. No, so you're absolutely right, Mary. And I think breaking it down as to what we're talking about here, I think is the first step, right? So for every exemption, right, which means your employees who you can pay a salary to, and you're not going to owe them overtime when they work over 40 hours in a work week. In order for those employees to be exempt under, we're really talking the main three exemptions, the executive, administrative, and professional exemptions, the employees need to meet a duties test, right? First, each of these has a separate duties test that, the employee needs to fall within. And then, as Mary said, what many employers forget is that there's this salary threshold, or some employers know about the salary threshold, but forget about the duties test. So employers need to understand that employees need to be paid on a salary basis, meaning it's a real salary, and it's at least as high as what we're talking about here. So when we get into this decision, it's really about the salary, the threshold component, taking over for the duties, and the court had an issue for the salary component basically becoming the litmus test instead of the duties. This may sound familiar to some people because it's kind of history repeating itself in some ways, in that this was what really doomed the 2016 Obama administration rule, which also attempted to dramatically increase the salary threshold. Funny enough, the same Texas court that stopped this rule stopped the Obama rule back in 2016. Though, again, in Mary, as you mentioned earlier, employers were in a better position there because the final rule was knocked down, I believe it was just a few days before it went into effect.
Yeah.
Unlike here, where what we have to unpack today is what to do once you came into compliance or did not, and what to do next. So it presents a different situation.
Brian, can you maybe say a little more what you mean? So on one hand, the punchline of this episode could be you don't have to make any change. All the change, and if you failed to make the changes that were required of you July 1st, then you're good. I think for the three of us, what we really want to communicate here is how should employers be behaving? Because one thing is certain, nothing is going to stay the same. Right? So this decision by the East Texas court could be overturned. We don't think it probably will be, but we didn't think this was going to happen either. So the DOL could come out with new rules. Things are going to change, and there are very practical things employers should be doing. I want to spend probably most of our time talking about that. But specifically on this being overturned, I know conceptually what you mean, but can you unpack for us the difference between what the court had an issue with a salary-centric requirement versus a duties-centric requirement? Right. That's gonna tee up what we are going to ask of employers in a second. So explain more, please.
Right. So what the DOL did in implementing this new rule was they increased how much someone has to earn on an annual basis or a weekly basis to be considered exempt. And the point of that, right, the idea behind the DOL's rule was to make it so that less employees would be exempt and more employees would receive, time and a half for overtime and get hourly rates. And so what the rule would essentially do was, I think studies showed that it was going to increase, to about 30 million, I believe, people who would otherwise have not been exempt would now, or rather not 30 million, 3 million, a little over 3 million would now become non-exempt. And so what the DOL said is that, rather what the court responded with was that this increase in the salary was so high that it was basically getting rid of the duties test, and that the exemption test was basically going to become a salary test. And the problem with this is that the statute, the FLSA, it only speaks of the duties when it talks about who's exempt. And so courts have been okay. And, there was a recent federal decision that said, the court can use, or the DOL can use salary as a proxy for duties, but only up to a limit. And so here the court found the limit was far exceeded because it would basically render the duties test meaningless. So that really formed the basis of the court's decision. It also, and I'll mention this, after 2025, the final rule contained every several years there would be automatic increases, based on some salary indexing. And the court said, well, DOL, you're not authorized to just set these salary threshold increases on autopilot, right? So the FLSA doesn't permit you to do
that. Those I never thought about until you just described it that way. Those auto increases down the road make it, they further cement the notion that this is all about pay, not duties, right?
Right, exactly. And so, that's not just, this is not certainly, as you suggested, a new rule could be implemented that increases the salary threshold, but, the courts are, stating it's got to be within reason. Now, we don't know what that really is. And again, speaking of going forward, right, what happens next, this is all, the timing of this is very interesting, right? Had this decision from the Texas court come down a year ago, it would be much different. We'd likely have an administration that would follow through with an appeal and try to get this final rule back in effect. However, come the beginning of January, we have a new administration that, based on what we saw in the first Trump administration, we would likely see them either not pursue the appeal, or even if they pursued an appeal, they might just do so to argue that they have such rule-making authority, but then they would likely withdraw this actual rule. So, what we think is that the rule may be dead at this point, but that's not for certain. So I think that certainly is something that we need to consider when advising employers, because right now we're still in a little bit of a time of uncertainty, though we do expect the rule will not come back into effect.
All right, so let's kind of split our conversation going forward here into two buckets. I think number one, I want to talk about those employers who maybe watch this show, Mary and Brian, and they've learned so much from you two, that this rule was coming in July 1st. They had some exempt employees who they had to raise pay. They were proactive, and they did that. So I want to talk about how do we treat that? Do we claw back? Do we just change, go forward? I mean, we need to give solid advice to employers what to do with those employees that requirement retroactively changed. What a nightmare, the word retroactive, and when it comes to following laws. And then the other half, maybe the bigger half here, if that makes sense, is knowing things are going to change again. We just don't know what those changes are. What is the best way to organize our business, our employee classification, our HR processes, so that we're best equipped to handle change, right? So let's focus on the first. So that again, the minimum salary threshold for an exempt employee, so not minimum wage, but you are exempt non-overtime salary folks. It used to be $35,568 a year, and July 1st it went up to $43,888 a year. So now that that's gone retroactively, those people who didn't know about the change and didn't make the change, there's nothing for them to do, right?
Right.
But those people who did, those employers who acted, good on you, acted proactively, responsibly, and followed the law, whether you loved it or hated it, doesn't matter, you followed the law. What the heck do those folks do now?
I'll take it from the employee morale angle, and Brian maybe can give more of a legal stance here. So look, I know, as I talk to employers every single day, I know this was a difficult piece of legislation and costly to a lot of employers. So on one half, they may have increased some individuals, which they said, they're exempt, clearly exempt, or maybe they made the decision that they work so much overtime, that it net raising the salary is going to be the same for me. Or they took an employee and made them non-exempt. Let's take the first example where they made somebody exempt, and they made somebody exempt and they changed increased their salary. If you take that salary back, it cannot be overstated. I don't think you have an employee out there who would say, "Oh, I see the law changed, go ahead and do that." I think it's going to hurt employee morale significantly.
Yeah.
I think any reasonable person would agree. And for those employers who say, "Oh, Mary, I don't care about employee morale," well, you should, because that is directly correlated to engagement. Engagement is directly correlated to productivity, which is directly correlated to how you grow your company. So, we all need to be concerned about employee morale. That's very important. For those employees that you made non-exempt, so you maybe didn't have to make that salary increase, and you have a job description that, can defend that. Well, now if you go to that employee, never mind, Mike, I'm going to make you exempt again. Well, you might have just opened yourself up to that employee going, "Now, wait a minute. I was going to get overtime. Now I'm not going to get overtime. What about the 10 years I worked for you and never got overtime and worked 10 hours overtime all the time?"
Right.
Again, it's going to be morale, but it also could be very costly. And you might have just triggered a lawsuit.
Well, and something we just talked about before we started the show is like, if an employee goes to ChatGPT or to Google, is this real? My boss saying, "Oh, this changed. I thought this was the law." The reason they made this change the first time is because the law changed. Well, all those thousands, maybe tens of thousands of articles that were published on all these DOL rule changes, the ChatGPTs of the world have read all that content, and they may or may not provide the proper context of the new rule that is 5 minutes old. In Google's algorithms and their bots, they've crawled with the thousands of articles that guarantee there are thousands more articles on the DOL ruling than there is the court overturning it, on November 15th. It's very likely your employees are going to do an AI or a search that is going to come back and make them think that the rule is still in effect. So who do they believe, right? I mean, this puts those employers in a very difficult position.
Yes.
Yeah, absolutely. And I think, Mary, going towards the employee relations angle, I think it's important for employers to think about how they communicated the changes in the first place, right? Like, did the company mention the new rule, or just because that's going to relate to what you say now.
Right.
So obviously, it's going to be a very unpopular choice to take someone who you raised up to the 43,000 level to bring them back down. But if you're going to do that, certainly consider the message in relation to the previous message conveyed. And from a legal standpoint, obviously, legally you can, decrease someone's wages. Again, a lot of employee relations issues to go along with that. The only real issue to consider is in many states there are notice requirements when someone's wages are changed, so you have to provide that. But the other issue with reducing wages now would be, what if there is an appeal, right? What if an appeal is pursued? We don't anticipate it, but it could be worth waiting a month, 2 months, see how this plays out in the short term, right? Before drop the wages again. Then you learn there's an appeal. Now we're waiting for that to be resolved. So it is a not an easy decision to make. And certainly, as Mary suggested, if the employer went the other way and made people non-exempt, that's a completely different beast to tackle. For the reasons Mary said, it both legal and right. People look at salary as maybe a good thing, and comes with respect in the organization, and going back to an hourly rate could be something that's looked at less favorably. So there are really a lot of employee relations pitfalls here, which kind of could be tied to legal issues if your classifications to begin with were not good, and maybe you had some people earning salaries who should have been earning overtime.
I think you're hitting on the real issue, and we're gonna see a lot of this in this next year or two in the courts, I believe, because this is going to be the foundation of so many lawsuits. And just so everybody understands it, I know we've talked on this show many times with all three of us, but at the raising the minimum salary. And the reason I'm hearing Brian tell me if I got this wrong, that the East Texas court struck this down is including all these increases over time, is because the rules seem to be centered around how much people make versus what people do. And what people do, that's the duties test that determines the classification, whether you're an exempt employee or a non-exempt, period. That's the black and white eyes of the law. And we all know that the real reason, so this was perhaps money centric. I'm not going to try to prejudge or get in the heads of the rule makers here. That's what the East Texas court said. But if the basis of moving, I can't afford to go from 35,000 to 58,000. That's too much. I'm going to reclassify you. Did I really change your job description? Did I really change the duties that are required of you every single day? Or did I probably just start calling you hourly and make you punch in and punch out now? I think the reality is most employers probably did that. They didn't rewrite the job descriptions and rewrite the duties, which means they were either improperly classified before or they're improperly classified now. And God bless all you lawyers, Brian. You're going to have a field day with employers who got this classification wrong, for people who are going to be eligible for all kinds of retroactive overtime, or why did you decrease my pay? And then amongst all of it, an employee relations nightmare. Can you maybe, am I on the right path here? And then speak to the employee classification issue.
Yeah, no, I think you're absolutely right there. So, I mean, look, I think, as Mary and I as I think we all started, right, was that employers may not always be aware of the different components of an exemption, right? That to be exempt from overtime, not only do you need to earn this much, right, 35,000 and change now, but you need to meet these duties. Sometimes employers think, oh, I pay them the salary, they're exempt, and they don't worry about the duties. So, you could have these employees you've been paying salary to who worked well above 40 hours, and so they were incurring, overtime compensation, but never being paid for that. So that's the biggest issue, those employees, right? And you take one of those employees and you start paying them an hourly rate in overtime, Now that's okay, right? We can pay anyone an hourly rate and overtime. But what's that going to tell that employee that, maybe I should speak to an attorney. Maybe I wasn't paid correctly back when I was getting a salary. That's often what I see in our practice, that employees go to attorneys when they feel something wasn't done right. Because, look, they'll get a free consultation, they'll talk. They might not even be going about the right thing, but the attorney will ask them the questions and figure out the claim. So we often
Yes.
see that, when things are not communicated well to employees, even if it was arguably legal, that, the employee might go to the DOL or they might go to the attorney, right? If they're not trusting what the employer does. So I think that goes to the communication aspect of this, right? That regardless of whether, any employer has skeletons in their closet, and some, potential liability, the way, and Mike, you and I discuss this all the time, the way you communicate to your employees, that's really so key, because if they have enough full understanding of why the company is doing what it did, and, it's explained in a thorough and understandable manner, it's much less likely employees will go to any outside source, right? Because they get it. They understand, we're all on the same team here. But it's where, you're going to decrease their wages or switch them again from hourly to salary or vice versa, that they're starting to have questions as to what is my employer doing? And that's when they're likely to go outside, talk to an attorney, talk to an agency, and you're likely to get some type of claim.
Mary, piggyback on this if you could, because I want to put a fine point on this. If you were an employer who had exempt employees, you may have called them salaried, but they're exempt employees, and they were making below $58,656. Excuse me, July 1st. They're making less than $43,888, and so you raise them up. The only way you could have, so if they were legally and properly classified, then that would have been your only legal path. So if they're truly an exempt employee, you had no choice but to raise their salary. If you converted them to hourly, the only legal way you could have done that is if you literally changed their job description so that their duties would have aligned with a non-exempt employee eligible for overtime. Am I saying that right,
Brian?
So I think it's almost the reverse, Mike. Just to clarify. So
I flip my words. Oh,
No. That's why it's so confusing for employers, and that's why I'm flipping it to Brian, because the DOL kind of looks at it. Sorry, Brian, I told you to start. Now I'm jumping in, but the DOL looks at it like everybody should get overtime.
Right. So that's the baseline position, right? Everyone's entitled to an hourly rate plus overtime, regardless of what you do. And then you're only entitled to get a salary if you meet certain duties.
You know what? You're right. I now remember. Right. So it can't work the other way, right. But you can always take a super highly compensated person. You could have a $200 an hour attorney, and convert them to be paid hourly. But you couldn't do it the other way around and take clearly somebody who doesn't pass those duties tests and say, oh, you're salaried because I want to even out your income, or I want to make cash flow more predictable, or whatever the seemingly noble reasons might be. Okay, I got you. We still, and again, tell me if I have it wrong, we still have a classification and duties issue that if you're going to change, that for you to be on firm ground as an employer, we still have to rely on good job descriptions that align to this classification, right?
Yeah, you have to defend the exempt classification because what we stated, and when you read the DOL, exempt versus non-exempt description, it's everybody's eligible for overtime unless. So that's kind of the way, and Brian could say it more articulately, but that's the way they look at it. So that's why job descriptions and I say this all the time, but I'm going to repeat myself because it's that important that the job descriptions have to be looked at every day. Things change. So what changes? Well, there's a lot of people that are remote now. So and that's a big deal because that changes your duties, right? I might have taken the mail in every day. I can't take it in every day if I'm remote a couple of days a week or 5 days a week. So you have to update your job descriptions. Absolutely. And what I would also caution everybody, if you have those remote employees, I have an employer who said, that's it. Everybody's going to be non-exempt. I can't afford that. They made a few people that were exempt, non-exempt, but they're in the state of Washington. And Washington, like New York and like California and many other states, have very strict laws. I would say Washington probably has the strictest about meal breaks and very strict consequences to employers if people don't take their meal breaks. They want everybody to take meal breaks, but they're going to be stricter on the non-exempt. So now you made everybody non-exempt, but you're in the state of Washington. Right? So now you have a new issue. Now you have to monitor whether that individual took a break, because if they don't, you owe them twice the amount of time for their meal break. How do you prove that a remote person took a meal break? I mean, so there's a lot of issues that employers need to think about when they're changing the exemptions, which they're still going to do, even though this law, changed for now, especially in a state like Washington, and New York and California, who have salary thresholds that are still increasing. And those are the states we all go, oh, of course, New York and California and Washington State have salary thresholds that are even higher than what the DOL was going to do. But it would surprise you that Alaska and Colorado do as well, and a few other states. So that's why it's just uber important to, pay attention, constantly get updates on what your state, the federal government and municipalities are doing, because they're all changing all the time.
Yeah. And kind of to echo what Mary said, I mean, so typically when we look at, exemption, these classification claims by employees, usually it's an issue with the duties. But now with this confusion over what the salary amount is, what the threshold is, and understanding that some states have higher thresholds, I think that's going to be an issue. But right, looking at the duties, I think Mary probably agreed. There's never a bad time to audit your classifications, either internally or bring someone in outside to help you with that. Because again, there are two reasons for this. One, you want to get it right? You want to make sure that you're not paying salaries to people who are not quite meeting these duties tests and should be paid overtime. But second, engaging, an outside party like Assure or Jackson Lewis to look at your classifications. If you ever get sued, there's a good faith defense that can, mitigate some of the damages or liability. And one of the requirements under federal law is that the employer attempted to comply. And how do you show that? Engaging outside parties, engaging experts in the field. Even if you get it wrong, the fact that an employer, took those steps and conducted audits, will go a long way and help them. So, this is probably a good time not just to look at, how you're going to treat the wages, but make sure your classifications are correct based on the duty.
Let's just create a practical punch list for folks. So you're an employer, okay? maybe my head is spinning about what this rule change meant for me, didn't mean for me. Maybe I acted on it, maybe I didn't. If you did, regrettably, you're in a very difficult situation that you probably can't unwind. But what are, we've talked job descriptions, we've talked exempt, non-exempt classification, we talked employee handbooks. What are the practical next steps that employers should be making to make sure that they're not flat-footed the next time a change comes, because change is coming?
Yeah, I mean, I think Brian's right. We always recommend doing an FLSA audit every year. And don't forget, audit usually the term means that somebody from the outside is coming in, because if you knew you were doing something wrong, you wouldn't have done it. So to audit your own work doesn't make any sense. So we always recommend that that is done every year. That part of that is going to be looking at the job descriptions. So I think this is a little unusual situation in that you're going to look at individuals, but remember that anything when we're dealing with in the HR world, you need to be consistent. So I know that doesn't make a lot of sense, but you're going to look at Mike and Brian and Mary and do that FLSA audit. And if we're all in the same position, but yet our job, we were given different job descriptions or we're being paid significantly different, that's a red flag because there's no consistency. But then when I look at each individual, if there is a small nuance, right? And this is where it gets tricky, right? And I go back to my job description, you have to have consistency, right? So you have to make sure that just because Mike has a master's degree in philosophy, but he's the marketing, director, and so is Brian and Mary, that philosophy major doesn't really matter. So that's not going to be significant. This is where, again, an expert from the outside, like Brian said, is uber important, because you have to look at what an incumbent is doing when you do an FLSA audit and you review your job descriptions, but it can't be the unilateral driver to what the responsibilities are on the job description. It needs to be driven by the company needs and what the incumbent is doing. But those specializations, probably are outliers. So I hope that makes sense.
It does. I want to unpack what are the top, 2, 3, 4 things that are in an FLSA audit. So first thing you talked about was job descriptions. You made the point of how consistency is important. I'll put that in the eyes of the auditor. What else is looked at besides just job descriptions in an FLSA audit?
Well, we're going to ask for a payroll run. And while I'm at it, obviously, I'm going to look for pay equity. We're not talking about pay equity today, but obviously it's very important. So we'd be remiss not to look at pay equity. So when I do that payroll run, if they have, EEO information on each individual, I'm going to look for that. If they have, hire date, so that I can get how long they've been with the organization, I want to get that. So obviously salary and how they're being paid and the position. So that payroll run is really going to drive where I see inconsistencies. And then I'm going to do a deeper dive. That deeper dive is always going to include looking at job descriptions, but I might also need to look at the resume of some of the individuals, because if I notice that Mary and Brian make significantly different amount of money, but we were both hired in the same year, I do need to take a deeper dive and find out why, because I'm looking at pay equity and inconsistencies, which is always a red flag. And I'll turn it to Brian, because he's going to have some additional deeper dive.
Yeah, I think one thing that I often find to be needed is that I'll look at a job description, and I still want to understand exactly what the person does. And so, sometimes we'll need to speak to a supervisor, someone at the company who can kind of explain what is this person doing. And I try to use those as learning lessons for a company, because if someone can't come in off the street and read your job description and understand what that person is really doing, you probably need to go back and address it, because these should be straightforward things. And again, they need to reflect what the employees actually are doing. So as Mary said, there might be issues in the credentials of people that can dictate, the exempt or non-exempt status. But the first place the DOL or a plaintiff's attorney will go in a case regarding an exemption is to the job description. So we really want to make sure those are regularly updated. If there's any change to the position, right now, if the company changed the exemption, right, went from making a position exempt to non-exempt, right, make sure that's updated on the job description, along with any duties that may or may not have changed, right? So this is a good opportunity to go back and update those job descriptions, and not do it in a silo. Talk to people on the floor to find out what's really going on, because often I find that's the biggest disconnect between HR thinks a position is doing versus if you talk to their supervisor, what they're really spending most of their time doing.
Yeah, Mary, were you going to add to that?
No, I agree. I mean, you do have to ask the incumbent what they're doing. You do have to ask the manager, and then you might need to go a level up. And it's really interesting. And I think it's like Brian said, it's a good exercise, because sometimes we will go, now, wait a minute, it does seem like Mike's the lead here, right? So he is making more money because he's the team lead. Maybe we shouldn't be such a flat organization. It's a great time when you look at those job descriptions to maybe change your organizational chart, right? It's going to leapfrog you into maybe some succession planning, et cetera. But a lot comes out of those job descriptions besides just, defending our exemptions. A lot of times they'll go, we do need a lead position, and Mike's it, and that's why he's making more money. He really is doing a lot more than, Brian and Mary.
All right. So I'm trying to wear the hat of an entrepreneur here. And maybe I have 5, 10, 15, maybe I have 20 employees. You start getting over 25 employees, you start to have the infrastructure, maybe an office manager. You get to 50 employees, you've got an HR manager, you've got somebody who is a payroll administrator. You get more specialized roles. But you're a small business owner, 10, 15 employees. You're the payroll manager, you're the HR manager, you're the founder, you're the probably product or service expert. This has got to be super overwhelming. And I think our advice is clear. I don't want to be mince words here. You need the advice of a third party, whether that's an HR service provider like Assure or an attorney like Brian. Let's also just be real world and know that if I hire a building inspector to come to my home, and I think I have a beautiful home, they're going to find a million things wrong with that. If I tried to fix everything on their list, the check would bounce. And so there's a little bit of I think for entrepreneurs, throwing their arms up in the air. It's like, okay, everything you just said made sense. I get it. This is just too much. Screw it. I'm just going to white knuckle it, treat my people the best I can, and hope they don't sue me. And I think it really kind of gets about that practical. What is our practical advice for those entrepreneurs about how to navigate these waters when they don't have a lot of resources, including not just in-house expertise, but money to pay for outside expertise?
It's a tough question, right? Because
but being an entrepreneur is tough.
Yeah,
right?
No, certainly. I think certainly from my perspective, from the legal perspective, I see these wage and hour issues as too significant to just say, all substantially comply, because decisions are riddled with issues that employers had where they complied mostly, but they missed one thing, and that can still be a big issue when it comes to wage and hour law. So I do agree that it's hard to do this on your own, right? Even employers that have their own internal HR department, that may not even be sufficient to ensure wage and hour compliance. So I think number one, employers should understand that just as anything business related, you're going to go to the vendor, the business, the company that is an expert in whatever it is you need. That employment law compliance, especially wage and hour compliance, it's very important to go to and find the resources. Obviously, all of us are resources. It's almost impossible to go at it alone, as you said. And we haven't really been discussing the state law parts of it, right? Mary mentioned before, the over 100 jurisdictions and such.
Right.
You could be an employer with one facility in one location, and you might still be dealing with federal, state, and city or local laws. So understanding how those interplay. Again, it's often more than just reading an article online is going to tell you. So I almost see it as that employers cannot afford not to look into this stuff and become compliant, because Mike, you and I have gone through some of the judgments that come down, and in wage and hour area with the potential class and collective actions. You have all these exempt employees and you were paying them all the wrong, salary. That could be a class, right? Because it's the same violation for all these people. So that's what we want, our clients and employers to avoid. And so, it might be, sometimes, this is a little more than, an ounce of preventative, measures. It may be a lot, but in the end, it'll be worth it.
And I'm not sure it is more than an ounce. I know it's overwhelming. And that's why I really want to acknowledge this. But Mary, I have my thoughts, but I want to share what your suggestion is for employers.
I think if they wanted to keep, the cost down, I think Brian's right. I certainly would look at your local Department of Labor and federal Department of Labor on a consistent basis. There's other free resources like our website, so we have information up there all the time. So does Jackson Lewis. So minimally, I think an employer, the information is out there, right? So, if you said to yourself, I'm going to spend 15 minutes a week researching, I think, it's better than nothing. And that's only 15 minutes. And I'm talking about free resources. The exempt guidance for the white collar exemptions and all the other exemptions are very clear cut from the Department of Labor, and they're a page and a half. They're pretty clear. So minimally, I would download those, keep them, on your desk, and give that food for thought. Absolutely. But, there is free resources. It's taking that information and then applying it to your organization. That's where it gets a little confusing. And then you add in state and municipal law.
Yeah. And guys, both of you, I appreciate, because this is what both of you do for a living. And I know the recommendation is to use services like yours. I do my very best on this show to just educate and try to help employers and not sales pitch here. I think this is really becoming more and more black and white every day. Forever, you may do your own bookkeeping, but you would never file your own taxes. You probably use a CPA to do that. So some businesses, as they're starting up, outsource all the bookkeeping, tax preparation. A lot of them do their own bookkeeping and they keep their QuickBooks and do whatever, but then they still give it to a CPA because they don't know tax law. A decade ago, there's a federal minimum wage, maybe a little more than a decade, but not much. There's a federal minimum wage. Now there's 150 plus. The leave laws and paid leave types and exemption this, not exempt that, duties test. how the hell is an entrepreneur trying to grow a landscaping business going to know off the top of their head what the duties tests are for for a salary exemption? I mean, that's crazy, right? I think my guidance to the entrepreneurs is acknowledge this is the new world. In the same way you hire a CPA to do your taxes because you're not a tax expert, you have to budget in something here. And it doesn't have to be an on-staff attorney.
No, not at all.
It doesn't have to be in-house counsel. This could be a once a year. Maybe it is to your attorney. Hey, once a year, I need to spend X dollars for you to look at my job descriptions, look at my handbook, and look at and analyze my payroll for a month to make sure that all those things line up. Or it's an ongoing service like Barry provides. I just think you can't, if you're an employer, you can't not budget part of this in and make that part of your cost of goods. And you're going to have to build it in. And when you price your services, the risk is just too high. And I think this has become way more complex than the average entrepreneur could ever possibly hope to keep up with. I think Brian, you mentioned it. We see more and more courts. We see more and more administrative agencies giving big fines and rewarding employees. The burden is so high in employers now. Man, you just have to make this part of running your business, and just acknowledge that maybe you can't keep up. Hopefully shows like this and content like this helps you become aware of the big themes, but then prepares you to then act on it. So probably about as sales pitchy as I've ever been on this show. But I think the call to action is really clear. I just can't imagine the average entrepreneur knowing how to act on all of these things. Awareness, great. That's the purpose of the show. Maybe Mary, I'll give you the last word here. And I'll bring it back down to earth. I'll get off my soapbox. The minimum salary threshold changed. Now it's changed back again. What's your closing argument for what employers should be doing and thinking about how to react to the East Texas courts strike down of this DOL rule?
Yeah. So again, if you didn't make any changes, you should be in good shape. That's what I want to say. So I don't want the employers who didn't make the change to say, oh, lucky me, I didn't know about it, so I didn't make the change. And now, and thinking about, should I change it back? That's not the case, because they do need to look at their job descriptions or make an attempt to make a job description. Again, you can look at the DOL duties tests. They're very clear. You can pull it right off the internet, or you can utilize an expert. If you made those changes, I think you first want to think about employee morale, because if that employee got an increase and you now take it away and they leave, right? We all know retention is very expensive. Now you have presumably a trained person who you valued, and they left, and that costs you 2.5 that person's salary. So think about that before you take back or change what you already put into motion. If you feel compelled to make that change back, the communication is key, right? When we do management training, we always say, you lose your authority and the trust with an employee when you say, Brian, I'm putting you on warning notice because somebody told me I had to do it, right? So you need to finesse your communication to that employee. Talk to that employee directly, right? Let them understand the why. I did give you this increase, Brian, this year. Instead of making $1 million, we only made 500. I really can't afford it now. You do deserve it, but we are going to move your salary back. You just have to talk to that person like an individual. If you feel compelled to do it, you really need to consider the consequences of doing it. So 2 different paths there, but both I am gonna say you really need to look at your job descriptions and make sure they're airtight.
Yeah. Brian, you got a better one, better close in you than that. That was pretty good.
No, nothing better than Mary's closing. That's exactly what I would say. I think we've addressed the legal considerations, but there's certainly a whole lot of employee relations that Mary discussed that go into these next steps for the employers.
Yeah. All right, guys. Really, really important topic. This thing has taken so many turns. When this preliminary rule was first published with the DOL, it's been over a year ago we started talking about this. I think we all thought it was going to come sooner than it actually did, and then when it actually did, now we have it was an incremental step change, and now we have a retroactive component. This thing has been a crazy ride. It just screams for having a well-run HR organization, no matter how big or small your company, because the smallest of firms have to follow the Fair Labor Standards Act. This isn't a big company thing. This is just a cost of doing business in today's world. So I learned a ton. You corrected me on a few things, Mary and Brian. So I do appreciate this. It's complex stuff. So thanks for joining me today.
My pleasure.
Thank you.
And thanks for everybody else and allowing us to be part of your mission to grow. Until next week. That's it for this episode of Mission to Grow. Thanks for joining us today. For show notes and more episodes, visit us at missiontogrowth.com. If you found this content valuable, I invite you to share it with a friend and subscribe to the show. If you really want to help, I'd love it if you left a 5-star review on Apple Podcasts, YouTube, or wherever you listen. Mission to Grow is sponsored by Assure. Assure helps more than 100,000 businesses get access to capital, stay compliant, and develop the talent they need to grow. To learn more about how Assure can help your business grow, visit assuresoftware.com. Until next time.